Today we're going to talk about challenging a will. This is part one of a two-part series. Today we're going to talk about the statutory basis for challenging a will. My name is Gregory Singleton. I'm an estate planning and probate attorney in Minneapolis, Minnesota. I work for Signature Law, which serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It sure helps support the channel. Okay, so death is an emotional time for many family members. There are many reasons that someone might challenge a will. I think we'll talk about those in another video, but today we're going to talk about the statutory bases for challenging a will. Now, there are both statutory and non-statutory bases. Today we're going to focus on the ones that are enumerated in the statute. The statute that we're talking about is Minnesota Statute 524.3-407. And there are 6 of them. And to start with, number 1 is testamentary capacity. Now, in Minnesota, in order to have testamentary capacity, the person who makes the will, I got to read this, so I'll be looking down. The person who has the testamentary capacity must understand the nature, situation, and extent of his property and the claims of others on his bounty or his remembrance, end quote, and be able to hold these things in his mind long enough to form a rational judgment concerning them. This is from the matter of Congdon's estate from 1981. So what does that mean? It means you got to know what you're doing when you're signing your will. You got to know what property you own, and you have to be able to keep that information in your head more than just a split second. The classic example of this might be someone who has dementia who signs everything over to their dog or to a politician or someone. They don't know what they have, don't know what they're doing, and they just do it. The second statutory basis is called undue influence. In Minnesota, this means influence of such a degree exerted upon the testator by another that it destroys or overcomes the testator's free agency and substitutes the will of the person exercising the influence for that of the other testator. Now, this is from In Re Wilson's Estate from 1947. Basically, what it's saying is someone has such influence that their intent is substituted for the intent of the person making the will. And now the language of that is, I think it's important. It says it, quote, destroys or overcomes the testator's free agency. That's a huge bar, and substitutes the will for the other person. That's got to be a high bar. Now, when you get into these claims, they are very, very fact intensive. There'll be a lot of witnesses. There'll be expert witnesses, doctors and such that come in. They're not easy fights to have. The classic example of this might be a young trophy wife to a very old man, and the young wife convinces the old man to cut out the children and leave everything to her by exerting her influence on the old man. Oftentimes, undue influence claims are combined with a testamentary capacity claim to give the overall picture. The third basis under the statutes for challenging a will is fraud. Now, this is a very complicated claim to make. I'm not going to go into all the details of it, but basically it's telling a lie while you know it's a lie, intending that the lie gets the other person to act, the other person being justified in acting on the lie, and the claimant being damaged. This is, we see fraud in a lot of commercial cases, but in the case of a probate, you might see this if someone, say, forged a will. Say they're the personal representative and they saw that they were written out of the will. They might have forged another will, gotten some fake signatures and witnesses, and all of a sudden show up with to court with a phony will that gives everything to them. That would be fraud. The fourth statutory basis for challenging a will is not a common one, but it is a valid basis. It's called duress. Now, this is basically forcing a person to change a will under the threat of harm. That could be someone just holding a gun to someone's head, or it could be a doctor saying, change your will or I'm not going to give you your pain medications. It's all duress, it's all not allowed, and you can challenge a will on that basis. The fifth basis is mistake. Now, this is a tricky one. This is essentially saying that there was a mistake in drafting the will. This could be something along the lines of having 2 kids and giving one the property and then the other kid the house that is on the property. That would be a mistake because the property generally runs with the building. Or it could be an accidental disinheritance of somebody in a will. Say you have 3 children, or let's say you have 10 children, you mention 9, but you forget to mention the 10th, and you don't have a disinheritance clause in there. That 10th child may come up and say, hey, they forgot about me, that was an accident, I should be in the will, I'm challenging the will. It's not an easy claim to make. You have to look to the intent of the drafter of the will, or intent of the testator, but they are ones that you see come up a lot. Now, what is not a valid basis for mistake, now, and I'm going to say mistake needs to be narrowed down. Mistake does not include such situations as, well, my dad promised me he was going to give me the house, and he promised that he was going to write a will to do that, but then he died without writing that will, and it was a mistake that he didn't write the will. That is not a valid basis for under a mistake. That's just simply not making a will. The 6th basis for challenging a will under the statutes is called revocation. And this is claiming that the testator revoked a will that someone is trying to probate. And in this case, and if the will was revoked, then either a superseding will is going to take control, or the intestacy statutes will take control of who gets what. The classic example might be a situation where a personal representative has a photocopy of a will, and can't find the original. So they try to probate the photocopy of the will. And then someone else comes up and says, hey, hold on. It's only a photocopy because the original was destroyed with intent to revoke that will. Therefore, the photocopy can't control. Now, it's generally really difficult to probate a photocopy anyways, but it can be done. So that's the 6 statutory bases for challenging a will. I hope you liked today's video. If you did, please feel free to smash that like and subscribe button below. If you have any questions, leave them in the comments below. And until next time, this is Gregory Singleton with Signature Law.